Hi, my name's Todd Smith. I'm a partner at Dana Whiting Law. Today, I am joined by Michael B. Rich, the best name for an estate planning attorney ever. How are you today, Michael?
Well, good, Todd. How are you?
Good. So today, I have some questions for you where I think there could be a good discussion for what you see from your end as an estate planning attorney that works on what we call our core estate planning. There's some issues that apply to a lot of people. And so I want to focus in on one particular issue, and this is what we call the AB trust, which that's what attorneys say, but that doesn't mean anything to anybody outside the estate planning world. So tell me, what are some of the concerns that we're trying to address when we're working with a married couple and we propose doing an AB trust?
Yeah, some of the most common concerns that we are addressing when we do an AB trust are most commonly is if we're talking about a family that's been blended. So we have a husband has kids from a prior marriage, a wife has kids from a prior marriage, and they come together. That's a blended family. It's very common for us to use an AB trust in that scenario. Or if we're worried about some creditor protection components, we can add in an AB trust to their estate plan as well to address some of those concerns.
So when you talk about the blended family, you're specifically talking about, okay, if I'm the husband and I die first and my wife's still alive and I've got kids that aren't children of my spouse, we're wanting to kind of protect the interest of my kids, where I want to make sure that my kids receive what I want them to receive, but that's in tension with the fact that I want to take care of my wife for the rest of her life, right? So you're telling me that AB trust addresses that. What did you mean when you said creditor protection?
Yeah, so every revocable trust does not provide any creditor protection. That's a pretty well-known fact. It's a common misconception the general public has that a trust gives you creditor protection. That's not true on a revocable trust. However, on an irrevocable trust, there can be creditor protection components to that. And in an AB trust, the trust splits into two trusts on the death of the first spouse. One will remain revocable. The second will be irrevocable, which is where the deceased spouse's assets will go into. That will be creditor protected for the surviving spouse's lifetime.
So that's what we're talking about when we talk about the B trust. It's
Right.
an irrevocable trust that holds assets of the deceased spouse for the benefit of the surviving spouse.
Correct.
And so any creditors that the surviving spouse might have, and creditors can be used as a broad term as well. I like to think just any kind of claims, right? So if we're talking about nursing home or car accident or any kind of claim against that surviving spouse, the assets in the B trust are protected.
Right.
And what about estate tax? What benefits are there in an AB trust with respect to the estate tax?
Yeah, with respect to the estate tax, what the AB trust provides is it ensures that we get full use of both exemptions. So every person in the United States, every taxpayer is given a federal estate tax exemption.
How much?
In 2025, it's $13.99 million per person. It'll go up to $15 million as January 1st, 2026.
Big number.
Big number. Less than 1% of America has an estate tax issue. But for those people that do have an estate tax issue, we want to ensure that we're using both exemptions to the fullest. And when we don't do an AB trust, when we pass everything to the surviving spouse, there's a higher likelihood we lose one of those exemptions. And when the surviving spouse dies, we only have one $15 million exemption to use. However, when we do the AB trust, we can ensure that upon the first spouse's death, we use their full exemption. And then when the surviving spouse dies, the second exemption is applied as well.
So one thing that I've noticed that is a concern of mine when I'm talking about estate planning for the people that are in that 99% that you were talking about, when if the exemption is $15 million, and that means a married couple can pass $30 million without worrying about the estate tax. So if we're talking about somebody that's $10 million or less in a married couple, there are reasons for doing the AB trust. We talked about some non-tax reasons, the creditor protection, the blended family issues. But when it comes to taxes, sometimes there can be a downside to the B trust. And this isn't about the estate tax anymore. This is a tension with the income tax. How do you present that issue to clients?
Or a tension with the capital gains tax.
Yeah.
Yeah, so the general rule is that irrevocable trust does not receive a step-up in basis on assets at someone's death, whereas a revocable trust, or if assets are just in your name, when someone passes away, those assets will receive a step up in basis. And so there's a tension between the estate tax and the capital gains tax. We use irrevocable trust or B trust to save in estate taxes, but then we lose out on some of the capital gain tax savings. So there's this tension back and forth between the estate tax and the capital gains tax. However, being that we hold ourselves out as tax attorneys at this firm, we do know there are ways we can put in what's called powers of appointment into an irrevocable trust and get the best of both worlds. We can save on estate taxes and still receive a step up in capital and save on capital gains taxes at the death of the surviving spouse.
That sounds pretty technical. Sounds like if somebody has questions about that, they're going to need to see you.
Well, LegalZoom won't talk about it.
Well, thanks for your time, Michael.
My pleasure.